There's a lot of advice on how to prepare for and go to divorce mediation successfully, but how good is the advice? Let's find out by reading this article first about how to prepare for a successful divorce mediation. I didn't write this one, but this article does contain some good advice and it contains some bad advice, which I'll explain in this 5-part series. Let's start with one of the good bits. Paragraph 2, quote, "Present your case to your mediator previous to mediation," unquote. Even so, this bit of advice is a little deceptive. Why? Because in my experience, when you take care to prepare a mediation position statement and to provide the mediator with copies of the relevant documents needed to discuss the issues, rarely does the mediator review these documents in advance. Like most people, unfortunately, most mediators want to make as much profit as possible. The more time they spend preparing for your mediation, the less time they have to spend doing other things they like to do. Mediators get paid the same amount of money regardless of whether they prepare in advance for your mediation or just wing it on the day of. Most mediators wing it on the day of. This, however, doesn't mean you shouldn't prepare in advance. Whether your mediator benefits from it, you will benefit personally from thinking over the issues and generating ideas for settlement in your case. The better you understand your case, the better you can educate your mediator. The good advice in this paragraph 2 of the article lies in extolling the benefits of preparation. The better prepared you are for mediation, the more likely the mediation will be productive. Preparation takes time and effort, and if you have an attorney assisting you, it takes money to pay for his or her help. And no matter how well you prepare, there's no guarantee of success. Boo! But seriously, good preparation is worth the effort nonetheless. Yay! Why? Because the more you prepare for mediation, the better you understand and appreciate the strengths and weaknesses of your case. The better you understand your case, the more likely you are to be successful in reaching a negotiated settlement. The better you prepare, the better you can determine what the possible fair, real-world settlement agreements might look like in your case. And the better you can generate settlement ideas and options. Simply put, it takes more time and effort to come up with Plan A and Plan B than just Plan A. And when you start asking what your options are, the more options you will notice. Imagine how much better prepared you'll be to settle on fair terms if you have a wide range of ideas on what all those fair terms could be and what form they'd take. And while the most productive mediation is one that ends in a satisfactory settlement agreement, even a mediation that doesn't end in settlement can be productive. If you don't settle in mediation, you may learn things in mediation helpful to you in your trial preparations. The better prepared you are for mediation, the better prepared you are to frame the issues and to discuss them. So even if the mediation does not end with a settlement agreement, you and your spouse may come to understand better the respective strengths and weaknesses of your respective cases.